Good morning, everyone, and welcome to the hearing today, where we are reconvening at the request of submitters the hearing in relation to the chapter of the plan that was advertised as sites and areas of significance to Māori. Previously, we have considered the Section 42A report from Council Advisors and also heard from the Hokanui Runanga in terms of a modified approach that they wish to follow. So today and tomorrow, the prime purpose is to enable submitters to make a presentation to us, and later today we will be hearing from Transpower and tomorrow from Federated Farmers and the Hokanui Runanga. Initially, however, we've got a procedural matter that we need to deal with, so I'll hand over to our legal advisor to discuss that, please.
Sorry, got the red light now. Good morning. Thank you. So just need to let the panel and the parties watching online know that we've had some travel difficulties this morning with Council's planner Ms Bennett due to lots of cancellations and flights turning back and difficult travel arrangements due to the weather. Ms Bennett hasn't been able to get here in person as had originally been planned. She is intending to travel to still be here for tomorrow, but it has put some restrictions around the original timetable, which, just looking at it on my phone at the moment, suggested that the council would be speaking or would be available to answer questions and make comments from 11 till 1 o'clock. So obviously Mr Heal and myself are here and we'd like to make arrangements so that Ms Bennett can put you in a position to be able to hear from Transpower at 1:30 as originally scheduled. So our suggestion is that the panel has time with Ms Bennett online to discuss any issues arising out of the Transpower evidence and legal submissions, and then we would seek leave for her to jump off and focus on trying to get here for tomorrow morning's hearing.
Thank you. And so as a panel, we've considered the options available to us and recognising the constraints that Ms Bennett faces. So today with her we will focus solely on the evidence that's come from Transpower. It is important that Federated Farmers hear what Ms Bennett has to say prior to them speaking. So the intent is that at 8:30 tomorrow morning we will hear from Ms Bennett and pose questions to her in terms of both Federated Farmers and Hokanui Runanga, and there's some sense in that as well, and that they can actually hear the responses. And it means that we will need to modify the hearing timetable for tomorrow, probably by shifting it forward. So if the staff behind me are able to contact the other submitters advising that in the case of Federated Farmers it is likely to be 9:30 when we're ready to hear from them, and the Hokanui Runanga it's likely to be about 11 o'clock rather than the 9:45.
Thank you, and I have also let Council for all of the other parties involved in the hearing know that this was happening and that we're having this conversation, so I'm also able to assist with rejigging things in the background, and I'll be keeping in touch with Ms Bennett during the day just in terms of how things are going with getting down here for tomorrow.
And the timetable that we've got tomorrow leaves a substantial period tomorrow afternoon whereby we'll be able to complete the hearing tomorrow. So then if we focus on Courtney Bennett. Good morning, Courtney. We appreciate the difficulty that you're having with travel arrangements and the constraints that you face. So What I guess for your benefit, this morning we'll talk to you about Transpower, then we'll hear the legal submissions. And a number of the matters that you've raised in your submission or in your evidence for the Runanga also come down to legal issues. In your hands for a brief introduction, just in terms of take us through, please, the key points that you've made in relation to Transpower. Certainly my focus has been on what you've presented with the Runanga, and so an update in terms of reminder of what's in Transpower and your comments would be appreciated. Thank you.
Great. Everyone hear and see me well? Fantastic. First of all, I appreciate everyone's flexibility with the weather issues today, but I'll be there bright and early tomorrow. So my name is Courtney Bennett and I'm appearing on behalf of Gordon District Council. My Section 42A report sets out my qualifications and experience as an expert in planning. I confirm that I'm intending to abide by the Code of Conduct of Expert Witnesses and set out by Environment Courts Practice Note 2023 as applicable to the Dependent Hearing Panel. I've provided 2 statements of supplementary evidence to provide a response to expert evidence presented in relation to Hearing Stream 9A. One responding to South and Federated Farmers and Transpower's evidence, and one responding to the further evidence of Hokonui Runanga. These have both been tabled and I'm taking them as read. Today I'll provide a verbal summary focusing on Transpower evidence only, with the other evidence to be discussed tomorrow, and then be happy to answer questions from the panel. Evidence was received from Aisley McLeod, tabled on behalf of Transpower New Zealand Limited. She raised several concerns, but in the interest of time, and since I'm taking my statement as read, I'll focus on the more significant or complex matters only. Ms McLeod has reiterated Transpower's preference for the PDP to adopt a mapped SASM approach due to its perceived practicality and closer alignment with higher order documents. I defer to legal counsel on the PDP approach's compliance with higher order documents. In terms of practicality, however, Ms McLeod gives the example of considering alternative sites. She implies that if specific sites are not listed in the PDP, then applicants will be constrained in their ability to respond to cultural values at place, particularly the requirement to consider alternative methods and locations. By engaging with mana whenua, applicants will be able to understand exactly what, if any, values are relevant at place for the proposed activity. This would allow them to meet their requirements to consider any possible alternative locations or methods for undertaking their activity. This may be different to their current practice, but it's important to understand that the opportunity to undertake this consideration is still available under the PDP approach. Ms McLeod highlights several issues with SASM 02 as proposed in the Section 42A report, which for clarity is identical to the Ngāi Tahu Cultural Values Objective 2 as per my HSH supplementary evidence. For example, she queries why references to kaitiakitanga have been replaced with references to rangatiratanga, which is a valid question. The rewording of SASM 02 to reference rangatiratanga instead of kaitiakitanga was proposed by Hokonui Runanga. Therefore, I defer to them to discuss the deeper intent of the amendment. However, at a practical level, I note that amending this provision to include a set list of Ngāi Tahu cultural values relevant to the objective created a duplication in the wording. If the original wording had been retained, then the objective would state that kaitiakitanga would be recognised and provided for when activities impacted on the value of kaitiakitanga. This would not have made much sense. So this in part is why the rewording occurred, so that it wasn't duplicating that wording. But as I said, I defer to Hokonui Runanga to provide a more detailed discussion of the difference in the different values and how they align in that. Ms McLeod also questioned the relevance of some of the Ngāi Tahu cultural values listed within the plan. Whilst in my written statement I provided some context for their inclusion, I note that Hokonui Runanga have now also proposed amendments to this list of values, so that would be something to discuss with them tomorrow. Ms McLeod raises several concerns with the drafting of mana whenua P1. In some cases I agree with these critiques. I agree that the wording in this policy is broad and that the content may be better suited to explanatory text and that it duplicates other provisions already in the PDP. However, this provision was proposed in response to Minute 15, which specifically directed process-related provisions be developed for the mana whenua chapter. In relation to its broadness and duplication, this is discussed in the SASM 42A report at paragraphs 93 and 96. I disagree that Mana Whenua P1 is problematic for potentially increasing the number of resource consent applications being unnecessarily notified. Whilst I agree that the SASM approach taken by the PDP may cause more applications to be notified, I disagree that this will be done unnecessarily. If an application is lodged and it is deemed that it is appropriately responded to any matters relating to Ngāi Tahu cultural values, then I would not expect it to be notified on these grounds. If, however, an applicant has not addressed these matters, it may be limited notified to relevant mana whenua. Instead of considering this unnecessary, I would consider this to be the notification process working as intended. Finally, I recognise Ms McLeod's opposition to the Ngāi Tahu cultural values chapter proposed by Hokonui Runanga via the Minute 15 response. I appreciate the opportunity to understand the Transpower position on this chapter and defer to legal counsel on the legality of its introduction. I'm happy to answer any questions or elaborate on any matters.
Thank you. I'll open it up to the panel, starting, I guess, at the right-hand end.
Kia ora, thanks for
You're not on.
can I join?
No, you need to warm it up. Yeah, take this one. Pass it, swap it over.
There. Oh,
No, come on.
it's
Just swap it. It's not. Thank you.
Okay, this one goes. Just kia ora. So I guess I have a bunch of questions that are probably going to wait till tomorrow around the Federated Farmers and Hokonui Runanga evidence. So I was thinking when I was reading through your supplementary, I'll pull up the paragraph number so that we're talking about the same thing together. So the note I've got is paragraph 48.
Yep.
And so it's this issue of resource consents versus designations. Is there anything preventing us from talking about decision-making processes, or just using a more neutral phrase? Are we limited in any way from doing that or adding reference?
The only limitation that I am aware of is that there isn't a specific submission point requesting it. That's why I've said in my supplementary evidence that if that's something that, if that's a amendment that the panel wanted to make, I would be supportive of that, because I agree with Ms McLeod's point that that wording does create an issue there, and I do think from a technical planning perspective it would be best practice to update that wording.
Okay, so the key is finding the umbrella submission that would enable that to occur. Yeah. Okay, and legal counsel have just said it could be a consequential amendment. And perhaps that might relate to the application of the NES, potentially. Anyway.
Well, the other matter is in terms of designations. Councils don't make decisions, they make recommendations as well, and the word decision pops up in a number of the different provisions, and it's actually not the right word. So it's a matter of something that needs to be, we'll look at.
Overall, I had a basic question, because you've indicated in response to the Transpower evidence that you're willing to explore a bit further the role of explanatory text. And so obviously what we did through the Minute 15 process was turn a bunch of explanatory text into provisions. And so I just wondered if you have some basic concerns about that and a preference for reverting in some respects to the notified approach and the explanatory text. Because I could see you were sort of in almost two camps around it, so I just wanted to explore that a little bit more and see, if you have a preference and why.
At this point in time, my perspective is that a lot of the content that has been rejigged into provisions still has a lot of merit as explanatory text, and a lot of the issues, well, some of the issues that Federated Farmers have highlighted and Transpower have highlighted, in my perspective, have become issues because they've been formulated as provisions, and I suspect that some of those issues may be allayed if they reverted back to explanatory text. I'm aware that Hokonui doesn't hold that same view, but I do think there is merit in reconsidering what is formulated as a provision and what is formulated as explanatory text in some parts of that chapter.
Okay, that's helpful. And so when thinking about what things might revert and what things might be provisions, is a key consideration the explanatory text is useful context, but in terms of legal weighting, provisions, have an operative legal weighting. Is that the hinge that we should be thinking about?
The provision that has been highlighted most commonly by submitters is the new Mana Whenua P1, which was an attempt to give a bit of a signpost to plan users about where they could expect to find provisions that related to Ngāi cultural values. So we developed a policy that said you may be required to consider impacts on Ngāi cultural values in these types of provisions, and we kind of grouped them together, created some kind of categories, and that provision has caused quite a few questions to be raised around duplication of the actual provisions themselves in the other chapters, whether or not having that as a provision is then going to implicate a number of activities that weren't intended to be implicated in this Ngāi cultural values approach, whether it covered enough things, whereas if that kind of content was explanatory text, it wouldn't have that weight, so you wouldn't be asking these types of questions because it's not binding in the same way from my perspective.
And so I was picking that up, and that was definitely a response to Ms. McLeod's evidence. So what it got me wondering was our exchange in December around this policy, was also a little muddled, right? And so what we established by the time we got to the end of it was the purpose was to indicate triggers. These are triggers that are sitting in the provisions and other parts of the plan. What I wondered is if the policy actually described how the plan has been formulated in that way. If it did that, then this material that you've got, that's causing issues, the list of things, might become explanatory text in relationship with a much simpler policy that's actually describing how the plan is delivering, through these triggers and rules, because that was a really important moment, extraordinarily frustrating for Ms. Barron at the time, I think, but that whole exchange in December was around this, and that understanding that these triggers are sitting in matters of discretion and matters of control, that is actually what's being attempted to be captured in this MWP1, I think. and perhaps we should just describe it as that, and then maybe this exchange that you've got between your evidence and Ms McLeod's evidence, that perhaps that material could be explanatory text. You know, that might get to the heart of it.
It is where we started when we were developing these provisions, and then the question became, well, is it giving enough information? And that's when we started trying to add more in, but the more you add in, the more concrete it becomes, so people are asking more questions around inclusions and exclusions, and it gets to a point where you're almost inclined to just list every single provision with a hook in it, which is not a great way to write a policy, as I'm sure we can all agree. So if we did pare it all the way back to where we started, I do think that there's some benefit in exploring that, because having a broader policy or just paring it all the way back to explanatory text, it takes, for want of a better term, it takes a bit of the heat off that policy, because I suspect that people will be less inclined to look for specific inclusions and exclusions if we were to present it in that way.
And the other thing that I think it does is, because we've been on a journey with the original notified version, and now all of the evidence in front of us, that the original journey and the difficulties that people were responding to in submissions were around how, some misunderstanding at least, around how the plan functioned, and that's some of what we're trying to navigate and address. And it seems that at the heart of it is this policy and the way that the rules have been structured to include these triggers for matters of discretion and matters of control only in certain circumstances. And that's really the answer to a relationship that exists across the district. So recognising the relationship exists across the district, but the plan is deliberately responding to particular activities and settings. And so that, I guess, making that clear, I suppose, in the policy is, I guess, what you were trying to achieve, and we haven't quite got there, but we're getting close. So maybe it's a blend. Maybe it's a blend of, a simplified policy and that explanatory text. So that's probably where I'm at. Yep.
Is that all? Venus?
You can ask somebody, possibly Courtney, explanatory text as opposed to provision. So that would give direction but not provide so much scope for enforcement or refusing a consent. How would it work? Okay.
Yeah, so you're correct. So explanatory text, so an explanatory text is more to help people understand the intent of the policies or the intent of the provisions, how they're intended to be used, any context that you need to understand why they exist in the first place. Whereas the provisions themselves, the objectives, policies, rules, methods, potentially, those are the things that decision makers look at to make decisions. So you can't say, and Matt can come in where he wants to elaborate as well. The provisions are things that you can say, yes, you are doing these things, no, you are not doing these things. You can't hold people to account in the same way around explanatory text. That's just to give people an understanding of what we were thinking and meaning when we wrote them.
Okay, so explanatory text is looking forward to getting the outcome, the result, rather than opportunity for enforcement.
Correct.
Now, would explanatory text replace some of the provisions or be a preamble to provisions?
It It depends on the direction that the panel's interested in taking. So you'll remember that the original Mana Whenua chapter had no provisions in it. It was all explanatory text. And then the request from the panel was to add some provisions in. So we took some of that explanatory text and reshaped it into a provision. So if we were to have provisions and explanatory text, we'd be doubling up in many cases. And as we've talked about, I think that there's merit in returning back to that content being more shaped as explanatory text than provisions, because in essence, a lot of those new provisions we've proposed through the Minute 15 process are really just restating content that's already in the plan.
Thank you, Courtney.
Sorry, I was just going to add to the general discussion. So if you look at the last page, which has the notes component to the SASM
Last page of which?
of 18th of February. So this discussion partly started through that list because it's the chapters in the plan.
Sorry, of whose statement of 18th of February?
This is Courtney's statement of
Right.
18th of February. The one she's just been talking to.
17th of February?
No, 18th. There's two.
So the last page of our
Yes,
17th
that's
is
right.
that.
Oh, is it? Oh, they're the same.
Right.
So, basically what this does is explains where you need to go to in the plan to look for the rules that implement the SASM or Ngāi Cultural Values chapter. And so that was the signposting in the plan when it was notified. And to a degree, policy MWP1 reflects the types of rules in those chapters. So another method you could consider is having a notes component to the Mana Whenua chapter like we have with the SASM chapter, which could signpost where you need to go to, which could supplement explanatory text.
Can I take it a step further, and it's something we need to talk about tomorrow? The National Planning Standards talk about the mandatory Mana Whenua chapter and goes on to state, and the integration of other matters throughout the plan. So the listing that's in Policy 1, my question, I guess, to both Courtney and yourself to think about for tomorrow is that is very specific as to the matters of potential interest. Why can't each of those items actually be in the correct place in the plan, i.e. integrated? So Policy 1 at present isn't integrated into the plan, but if we took each of the bullet points and put them into the relevant sections, it would be.
Sure, we can have a think about that and come back to you. I guess the tricky thing is, though, if you take proximity to rivers and streams, those rules are in every zone. So it's whether you want a signpost that takes you to multiple places, or you'd have to duplicate things across multiple zones where that's discussed. But we can have a think about that and come back to you tomorrow.
And the other side of that is, and what is the effect and what is the purpose of that particular provision, which then helps signpost where it should be. Because we have duplication of rules throughout the plan, and the weakness that we have in the plan at present is the way that cross-referencing is done but also I think, personally, I have a desire so that if someone picks up a chapter of the plan, they've got a good indication that everything they need to know is either there or flagged very explicitly, rather than having to go to a values chapter or some other chapter to find out you need to go back somewhere else. And to me, the key may well be in addition to how the plan works. So for Courtney, the other point that's raised by Transpower is that when they go through a process of choosing routes for their high power lines, they probably want to go through a preliminary exercise before they consult with anybody. And their key point is that if they knew that there was a site of significance to the mana whenua, then they'd be able to rule that out early in the process. And from their point of view, what is the value of going to the mana whenua and saying, look, we're looking at putting in a new line, where shouldn't we go? So I think that's where they're coming from. And what's your view on that?
I understand where they're coming from, but from my perspective, that's an operational issue for them. My understanding from their reading is that they have a piece of software or algorithm that they use, and this approach would make it inconvenient to use their current algorithm. And I'm unsure whether we should shape the district plan around one person's preferred workflow.
Okay, thank you. I've got no further questions on Transpower. Anything else from the panel? Maria?
I just want to spitball a potential wording and just to throw it into the mix. So something like the first part of the string remaining the same, the effects on relevant Ngāi cultural values are considered when resource consent is required for activities most likely to impact on those values through matters of control and discretionary considerations, or something like that. You know?
That does reflect the approach that the plan is taking. The only thing that picks up to me after reading the submissions that have come through from people that have concern with the process in general is talking about likely activities and unlikely activities. I'm comfortable with that wording, but that might be something that other submitters may have positions on, based on their previous positions on using terminology like high-risk activities and things like that, which was brought up often by submitters.
Yes, and I think that's something we can pick up again tomorrow with Federated Farmers. Okay, kia ora, that's probably me.
Oh, good morning, Courtney. Just following on from that, so you would take out the word some activities?
It's something that I would want to look at in more detail before I give a particular recommendation. I'm just highlighting that that is something that has been brought up previously, so it deserves to have some more thought put into it before I say yes or no on the fly, if that makes sense.
That appears to be all. Thank you, Courtney. So we'll wrap that up here. Safe travels, but given the weather forecast that we have for the south, if there's any issues with travel, then we'll deal with this by way of the same process tomorrow of bringing you up online if you don't manage to get here, and it works perfectly well.
Don't you worry about that.
All righty. So safe travels then. Thank you. So we'll now turn to legal submissions. Shelley, in your hands, if you, as I said before, the amount of material that we've had placed before us over a very short time frame is such that probably need you to go through in a little bit more detail in your submissions today than is normally the case. Thank you.
Certainly, and please, happy to take questions as I go rather than all at the end, if that's going to be easier for you to deal with the issues there. First of all, I have to apologise. There are typos in my submissions. I obviously was running late with filing them, so please accept my apologies for that. Not to the standard I'd normally want to provide them to you. There's only, apart from the typos, which I find glaringly obvious now, I did just want to make one change to a wording, please, in paragraph 21A. If I could just change the word overlay to basis, please. Provided a basis rather than an overlay. Overlay's got too much baggage, I find.
Might just need to wait so that everyone has got their copy in front of them.
And I'll reiterate it when we get there as well, so I can
That's helpful because I had a question on that.
The legal
Sorry.
submissions. Okay. I'm just going to ask the staff if they can run off another couple of copies of the legal submissions, please.
Would you like me to wait?
Yes, please. It's all right. Cool.
Sorry, before I start, I did just have a note here from Mr. Heel that he had his travel tomorrow was planned for him to depart at 1 tomorrow, and that was based on the original time frame. So if you have questions for Mr. Heel, it might be, we might load those into today in the gap that's now been made anyway.
Or the other option
Yes.
is we just do those first up tomorrow at 12.
Yeah,
Yeah.
there are clearly some questions that need to go to Matt Heel, and probably immediately following Courtney's tomorrow, there's probably some things that need a wider perspective across the plan, so we can deal with them then. Yeah, if there's any change from that, we'll come back to you.
Thank you. Appreciate accommodating. This is a bit of turning out to be a bit of a tricky hearing in terms of timing. So just picking up my submissions, probably at paragraph 2, just noting the previous legal submissions which are relevant to your consideration. Legal submissions already provided on behalf of council, but also there are legal submissions from hearing stream 3 and hearing stream, the one in December 9, from Hokonui Runanga, and I will cross-reference one of the Hokonui submissions from hearing stream 3 when I get to the relevant topic further down. It's not intended to replicate those submissions, though I have made some points which build on the earlier points made. So I'll just turn to the topics that I addressed rather than reading out the summary of what I'm looking at. Initially referencing the earlier submissions from December, which provide a summary of the most recent and directly relevant case law in my submission that is available to the panel in considering evidence about cultural values. That's the Port Tauranga case. In summary, and I've included the reference in my earlier submissions, it was the Principal Environment Court judge found that it is mana whenua that is best placed to identify values of importance to mana whenua. Thus, I would submit in the present process, it is for Hokonui Runanga to identify its cultural values for this district, and it is for Hokonui Runanga to give evidence on its relationship with land and water in this district and assert, for example, how the cultural value of kaitiakitanga should best be exercised. In my submission, the panel will need to exercise caution in accepting evidence from another party which seeks to contradict Hokonui Runganga's evidence on what mana whenua values are.
Before we move off that, I really appreciated you providing us with those two cases, the Albany North one and the Port of Tauranga one. So having read Port of Tauranga, I wondered if we might also, it seemed pertinent to me that the court determined that the port company's claim to not understand iwi interests and values did not absolve them of the need to respond to the information provided by iwi and hapu and address effects on them. So is that relevant when we're thinking about the role of iwi management plans applicable to the Gore district and other assessments and information provided by Hokonui Runanga that can assist understanding of effects, like Apiti Hono, Tātai Hono? So that part of the Port of Tauranga decision really jumped out at me, and I'm sorry I didn't write down the paragraph number in the decision. That's not helpful, but it's basically at the point that they're starting to sort of sum up where they've got to in their deliberations, and and that it seemed to me they were clearly stating that the company's claim to not understand and therefore not be able to address effects on the values of the relevant iwi and hapu was not a suitable response.
So very long judgment, and I wouldn't want to summarise it wrong, but one of the takeaways that I had from that case is that the port hadn't understood the values but also hadn't engaged over a very long period of previous consents, and the court did not accept that not doing making those efforts was sufficient to walk away from what the point you're making. And I would I do think the evidence that's been produced is of considerable importance, and I did make a note to cross-reference Hokonui Runanga's earlier submissions from hearing stream 3, which do reference Apiti Hono, Tātai Hono. Sorry, I've got a few documents up. And the submission at paragraph 19b summarises that that is a key plank of the evidence that is provided, and it was provided in that hearing but is relevant to this hearing. And then in paragraph paragraphs 57 to 63, it sets out how that forms the basis of the evidence being provided to the panel in terms of mana whenua values and mana whenua relationships in this district. So yes, my submission is you have that evidence before you to be taken into account, and that is the essence of the point I've just made in that start point of my submissions, that you should exercise caution in turning to another piece of evidence which seeks to contradict it if that is not from a party which has standing to be able to present on mana whenua values. Does that answer your question in part?
It does. And is it also then, I took from that, the responsibility to engage, so engaging with the material and information that's provided by iwi and hapu and engaging with iwi and hapu, those two things?
And I think the second part of that is around that kaitiakitanga, which I also turn to address shortly. So can I park that a little, because I think that is a unique value which in English it's translated poorly as stewardship, and I think that that is probably one of the more difficult cultural values to find a place for in a planning document, because it's not translated, it's not sort of applied in terms of fresh water, it's applied in a different manner. So just that part is my third section, so can I park that for now? So the second section of my submissions look at the national planning standards, and I'd just like to say that planners are very precise people, so I understand that this is causing consternation in terms of the proposed shift, and again that reverts back to the point, to the summary provided around the āpiti hono tātai hono approach, which is in the evidence from Hokonui Runanga from Hearing Stream 3 and summarised in submissions from that hearing. Hokonui Runanga has recorded that the identification or mapping of certain parts of the district as sites of significance is not an approach that it, as mana whenua, adheres to. And then this comes to the point we've just discussed with reference to the Port Tauranga cases cited above. It is submitted significant weight must be placed by the panel on this evidence to the effect that mapping and identification of a series of smaller SASMs, as they are so now universally known, is not relevant in this district.
So, reference is made in the Transpower evidence and legal submissions that the regional policy statement directs that the areas be shown, and we must give effect to that. So from a legal perspective, what is your view?
Can I pick that up when I get to the specific submissions I've made in respect of the Transpower submissions? Thank you.
Sorry to interrupt
yes.
you, Shelley. Just wondering, because I thought Hokonui Runanga ruled out using Aotearoa, Tataihono.
Can I suggest that question is directed to Mr. Leckie, but I'm reading from the submissions.
Mana whenua submissions, they were asking for it in the December hearing. They acknowledged that it could come out because it is a method available. It may not be their preferred method moving forward.
And this may be my understanding of how the framework operates in terms of identifying cultural values. So while it's not and so perhaps I need to stop calling it āpiti hono or tātai hono, but it was more driven by the method of not identifying small sites, but the preference for cultural values to be identified with respect to activities across the district and the how it affects mana whenua's relationships with land and water. So I'm using that as a shorthand for that alternative approach, so I apologise for that. That's been confusing. I'll stop doing that. Sorry. So am at paragraph 7 of my submissions. I'm just reading those. Although the Section 42A report and other planning evidence received by the panel does confirm the approach the approach proposed in the notified plan would not have created specific consents being required or cultural values being applied as a matter of consideration for all activities across the district, a range of submissions on the PDP expressed concern that that was what was happening. Directly in response to those submissions, the Runanga and Council, with the direction, guidance of the panel, has developed the Ngāi Tahu Cultural Values chapter, which is, in my submission, still able to respond to the relationships of mana whenua to all land and water in the district, and also enable Hokonui Runanga to exercise kaitiakitanga over the activities that have the most potential to affect Ngāi Tahu cultural values. But it does not retain the SASM label that the community has expressed significant concern about. In my submission, the Council is cognisant of and has been taking full account of the District Plan Standard in Section 4 of the National Planning Standards during this PDP process. It is not accepted that a SASM chapter is a compulsory part of the District Plan, and it is submitted that the Ngāi Tahu Cultural Values chapter is able to be utilised if the evidence before the panel calls for it. As recorded in paragraph 2 of section 4 of the MPS, and I've included a page reference there, chapters and sections shown in black in the table must be included in the district plan. Chapters shown in grey must only be included if they are relevant in the district. So my submission is you have evidence before you that says that a SASM chapter is not relevant in this district, but that a Ngāi Tahu Cultural Values chapter is relevant in this district. In line with the optional approach confirmed in section 4, paragraph 18 of a later section of the MPS, which addresses this particular part of the plan we're talking about, also clearly contemplates other chapters might be included in the PDP addressing historical and cultural values. So it says, any additional chapters to address other historical and cultural values on a district-wide basis must be included alphabetically under the historical and cultural values heading. So my submission is, this is such a chapter and it can be included in this section in line with that statement.
Can I just check there, because that's a must. Any additional chapters must be included alphabetically under the historical and cultural values heading, but we've obviously got the alternative floating around, which is the strategic directions option. And so how much weight should we be giving to that must in the National Planning Standards in your submission?
And from the council team, we've been operating under quite a constrained time frame, and as have you. So probably if we'd had a little bit more time, we would have been able to present this a little bit more in an aligned way. So my legal submission is that the direction I see in the MPS is that it should go under this heading. I hear the comments around an alternative location, but I'm also understand that Ms Bennett has a view around the inclusion of objectives and policies. So I think we need to look at that. But at this stage, my submission is this, for me, as the Council's legal advisor, tends to suggest this addresses cultural values and therefore should go in this part of the plan.
And that's on the basis of the structure that it is at present. And I think the task that we face is that the first step is we need to determine what is the structure of any additional chapter, if at all. And once that structure is determined, that will probably dictate where it goes in the document.
Well, I think it's also a give and take relationship, because it may be that you need to also consider what it's addressing as a part of that, rather than formulating what it needs to look like. This is also has to feed into what you're formulating. So my submission is it addresses cultural values, and that's contemplated as going in this section of the plan. It is also, in terms of the later issue of scope, then a direct shift across rather than a complete pick up and move in very colloquial terms. So just in this final sentence of paragraph 10, it is submitted there is evidence from Hokonui Runanga to support the approach that is put forward for the panel's consideration and a clear RMA basis to do so. I just include at paragraph 11 a note that if the panel does not accept the proposed Ngāi Tahu Cultural Values chapter in order to respond to submissions concerning the evidence from Hokonui Runanga, then the evidence it has before it would still require, in my submission, provisions to be included in the plan to respond to the cultural effects of all of these key activities in the district. So you do have sufficient evidence to require an appropriate response on these matters. At this point of the proceedings, the only fallback, or I think only is maybe a little bit too black and white, but one of the key fallback positions available to the panel would be then to accept the notified approach of having this district-wide concept of a district-wide SASM concept across the whole of the district. So again, I've used it layer, so I hope that you haven't taken that. Apologies. In my submission, it's clear the great weight of submissions are opposed to the district-wide SASM approach concept. Therefore, it is submitted that the response of Hokonui Runanga in refining the NTCV provisions to require assessment of cultural values is both an appropriate and helpful response to those submissions. In the next section, I just summarise again the key provisions of the Act which are relevant in this context, and also note the Ngāi Tahu Claims Settlement Act, which requires Council to have regard to the statutory acknowledgements, including in relation to the Mataura River, taonga species, and nohoanga. So just reminding you of your obligations, which I think underlines the point I've just made, that there is evidence to require a response to cultural effects and a requirement in the RMA to do so, to find an appropriate way to do so moving forward.
So before you move off there, surprisingly, because it's a very small paragraph, I actually have a bunch of questions to ask you on this. So I wanted to start with that statutory acknowledgement for the Mataura River. Can we rely on this document to establish the relationship of mana whenua across the Mataura catchment within the Gore district, i.e. lands and waters, tributaries and main stem? So I'm thinking about section 2111 of the Ngāi Tahu Claims Settlement Act.
I think I'd need to look in more detail at the wording of the schedule, which contains the specific statutory acknowledgement, but certainly in probably also it would be appropriate for that question to be directed to Hokonui Runanga. But in my submission, yes, it is a very important part, particularly of the mana whenua chapter, of having those statutory acknowledgements. And I also would submit that in terms of kaitiakitanga, for example, there is a key relationship which is acknowledged in statute, which requires that very direct kaitiakitanga response. So it's in terms of the statutory acknowledgements, there is a stronger need for the plan to respond to that particular area.
So what I had on my mind was that we know that most of the district is in the Mataura River catchment, and the bits that aren't is where some waters flow into the Mata o Clutha River and some that tributaries to the Ōrite River, and both of those rivers have statutory acknowledgements on them as well. So I guess what I was getting at was the combination of these that show the Crown has acknowledged the relationship to these catchments. Is that also providing weight alongside the Hokonui Runanga evidence that we have around the relationship across the whole of the district, i.e. these things are sitting in statute and potentially supporting that position. So I just wanted to understand if I'm on the right track there, and how we might think about that.
Yes, I would agree that there is not a need for evidence to be produced to underline the relationships that are enshrined in the legislation in the Ngāi Tahu Claims Settlement Act. So while you do have evidence before you on that issue, the points, the information in the statute doesn't then need to be tested in an evidential manner. So, and I didn't provide the references from the Settlement Act, but it's 200 and something in terms of requiring councils to acknowledge, to take account of the statutory acknowledgements in their plans. So apologies for that. I can provide that reference subsequently. So it's not, I would say that yes, very much so it is to sit directly alongside the evidence and to be not questioned really. I think it's most relevant in terms of the specific activities, land use activities beside those waterways. So I do agree also that it would add more weight for an appropriate response to activities in those areas, earthworks near waterways, for example. But I think that probably in terms of how you apply the Act, it would be radiating out from the Matoda River being the key location with the statutory acknowledgement.
Yeah, so I was thinking about the relationship with catchment, which obviously brings land and waters together. And then I thought, well, if that relationship is sort of already confirmed and supported by other evidence from Hokonui Runanga, is it therefore that we are in this process just considering how best to make a workable plan that recognises and provides for that relationship across the district?
I'm not sure that other parties would see it so simply, but in my submission, all of that information very much requires an appropriate response, and then how you formulate that response is based on what's been proposed and all of the submissions and things like that. But that section of my submissions is intended to very much reiterate that there is a high obligation on you as a panel to respond to these key directions in Part 2, and also, yes, the Ngāi Tahu Claims Settlement Act. And where there is, I would agree with you that there is a higher obligation in respect of the Matoda River. There's a nohoanga on the Matoda River, and I'm not sure where the taonga species, I haven't drilled down into the detail, sits in relation to the eco chapter or other chapters, but I've just noted that there for now.
Just for, remind me, nohoanga is a species in Honga.
Nohoanga are locations where the Settlement Claims Act provides for nohoanga to be utilised by Runanga on an ongoing basis. So they have a direct relationship with identified locations around the South Island, and there is one such location on the Matoda River which is noted in the Act. Hopefully I've got that right. Possibly might need to check that with Mr. Leakey.
So how does that site then get protected if it's not listed or specified in any way?
It is listed in the Act, and then I would have to check the maps to see how it's whether it's mapped or identified as a location.
Okay, yeah, if Mr. Hill can come back on that tomorrow would be helpful, thank you.
Paragraph 14, just as a wrap up, my submission is due to the strength of the directions in Part 2, the Ngāi Tahu Claims Settlement Act, and also in the evidence before you, I would submit the proposal by Fed Farmers that the Mana Whenua, SASM and or Ngāi Tahu Cultural Value chapters be withdrawn is inappropriate and should not be accepted by the panel. At paragraph 15, this short section looks at methods in the Mana Whenua chapter, and I have set out there the definition of kaitiakitanga that's in the Resource Management Act. So section 7A requires special, particular regard to be had to kaitiakitanga, which means the exercise of guardianship by tangata whenua in an area in accordance with tikanga Māori, in relation to natural and physical resources, and includes the ethic of stewardship. So in my submission, the inclusion of further methods in the Mana Whenua chapter is appropriate to respond to this particular cultural value, and I would acknowledge that it is a slightly unique value, which in my submission does require, the evidence shows does require processes to be followed rather than the usual types of processes followed involving Mana Whenua, which is slightly outside the ambit of other methods which might be employed elsewhere in the district plan.
Are you satisfied that we do have scope to include these methods as opposed to leaving them as explanatory text as per the notified version?
I think I'd need to sit down with the specific wording, which I think is probably still a little bit unrefined at this stage, but I agree that neither are rules. So rules are rules in terms of the enforcement point that you were making earlier, so neither are rules. Methods are probably more directive at council staff. So I would suggest that where it is setting out and applicants, so where it is setting out steps which are easy to follow for plan users and for council staff processing consents, that might be more useful as a method, and then perhaps when it sits outside a direct method and is explaining what's being achieved, perhaps that could then shift to explanatory text. But I think it's a drafting point which I would appreciate the chance to look at again as we work through the wording and possible shift of some into explanatory text.
We also face the issue that under our delegations we don't have the authority to commit the council to financial expenditure, including things like training. So I would probably pose the question in terms of whether we can actually include things in the plan that commit the council to dollar spending.
I'd need to think about that. I think that many district plans include methods which anticipate staff taking particular steps, and those steps might not be taken until 10 years down the track after the plan has been becomes operative. So I take your point, and I can look at that in more detail. I don't think that method in a plan necessarily means that it will happen overnight. So I would suggest that that can be dealt with a little bit more less black and white way.
I guess the flow-on issue from that I'd like you to have a think about and come back to is what is the role of the Charter of Understanding with the council, and is acknowledgement of the Charter and the issues that it addresses sufficient to actually achieve the outcome that you're thinking of?
And again, I think some of that's drafting as well, because language can be directive in a very firm way, and it can be less firm. So some of it is around drafting and finalising, which in my submission is also for the panel. to make a decision on, and perhaps in the instance of this particular topic there are points at which we will need to hand things over to you to make those decisions, because as much as the council team has done its best to present fully formed provisions in almost all respects to date, the process that has been followed, and it is part of a public process, it becomes a little more muddy and does call on the panel to make more or less decisions in different instances.
I think if I can just
Sorry.
follow up in terms of methods and binding council. So typically when plans are developed, if you have methods that are aiming to bind council, they get approved at notification, because the council is approving the plan for notification and it's considering the implications of those methods at that time. If methods are proposed through the hearing process, then I would imagine that the panel, if it wants to pursue methods, would need to make a recommendation back to council before they can incorporate those methods that financially bind council.
Just exploring the Charter of Understanding question, what relevance does it have to the plan process, and does it have statutory weight within the planning process?
Can I come back to you on that one? But certainly it is a relevant document in this process. It is a document that the council has bound itself to. So I would say it is very much relevant and should be taken account of. And then in terms of weighting, it probably sits alongside all of the other many documents you have before you to consider and to find an appropriate response to. And this is the tricky part about plan making, is your decision is what's most appropriate, and it's appropriate in response to so many documents. So I would suggest you need to take it into account, and I would suggest you also need to reference it in your decision, because otherwise you haven't taken account of a relevant consideration, which is one of your obligations. But then how that sits in relation to particular items, such as methods, I'd need to look at and make a specific submission on.
I'll assume it has weight within in respect of the relationship with the Runanga and the council, but specifically, what weight would or may it have under the RMA in respect of the district plan?
No. So that's what I tried to say, is that I agree that it's a document and a matter that's relevant for you to consider. And then in terms of how relevant it is to a particular provision, I'd need to look at that in the light of the other information you have relevant to that provision. But overall, in terms of the issues that we're discussing at this hearing, I would submit it as a relevant document and one you should take account of, and one that council has committed itself to in terms of moving forward. But then how that plays out in the district plan, I'd probably need to look at what all of the other, in terms of a method or an explanatory text, I'd need to look at how I would the council's cases in relation to that particular provision, and whether it adds support for a particular approach or detracts from a particular approach.
I guess one will have to go back and reread the document, the specifics. I'll just jump in and go back slightly, ask another question. You mentioned the way the submissions oppose the content of the SASM chapter. Is that the same as opposing the inclusion of a SASM chapter, or is it different? You said that the weight of submissions opposed the content of the SASM chapter, that attracted a lot of interest. Now, is that the same as opposing the inclusion of a SASM chapter? On one hand, we've got submissions opposing content.
So I would suggest that, so the submission I gave earlier was that there was significant concern, and so I started with an acknowledgement that it wasn't that there would be a district-wide SESM. So the evidence shows that's not, when you get down to how the rules that were notified work, that's not how it actually played out. But then I identified that the submissions showed that's not how members of the community necessarily appreciated that. So I said that in terms of a response to that concern, which maybe didn't quite appreciate exactly how things rolled out on the ground, then that was one thing that we could respond to. In terms of the difference between a chapter and content of the chapter, that would depend on each submission. So some were very general submissions which responded to that concern. We don't know what this district-wide SESM thing is. Some of them responded to a SESM chapter, and then some of them responded to separate parts of the chapter. And this is the 3 different layers that you as a panel are grappling with. Yeah. So, and I have tried to respond at those different layers, and I think probably in terms of the very specific rule layer, that's where I caught Ms. Bennett and Mr. Heal are more able to respond, to assist you with that in terms of drafting, and then I have my submission, certainly in terms of scope, which is the next section I'm coming to, has also tried to look at it that general view in terms of what is the SESM chapter or the Ngāi Tahu cultural values chapter trying to do. But then I've also acknowledged there's this other community concern, which is just, what is this thing? And so in my submission, that's also something which you can take account of in your decision, because if it means that we're getting rid of that misunderstanding or that fear through an alternative drafting approach, then that is a valid option for you moving forward.
I guess we're already into it already. I may have picked this up wrong, but there was a mention of mapping specific sites as opposed to a general overview considering the whole district as a SESM site. And I think you said a whole series, mapping specific sites or a series of mini SESMs would not be appropriate in this district. Were you quoting another circumstance? Or
I was referring to the evidence you've received from Hokonui Runanga, which says that's not an appropriate response in terms of Hokonui Runanga's relationship with this district, to land and water in this district. Yeah, so it's directly reflecting upon the evidence you've received from Mana Whenua about Mana Whenua's values in this district.
Thank you.
Shelley, can I just clarify, please, that a Charter of Understanding is not a legal document, it's like an MOU?
Semantics. I would say it's like an MOU. You had a copy handed up to you in December, so it is a document before you that in my submission you should take account of, and Mr. Nicholas addressed that charter and asked you as a panel to take it into account. So it's a piece of evidence. It does have council as a signatory, but it's not perhaps like a piece of legislation in terms of that creates an offence. It's possibly not as, doesn't have so much consequences that flow from it, but that would probably not be how the Runanga would see it. They would want to hold council to account, I'm sure, in respect of some aspects. So I think that's a buck each way answer.
I guess the
Another
other
way
way.
to put it, that is, that you said it's something that must be taken into account, and that was the language that I wrote down, is another way to put it, that it's something that can't be ignored in the decision-making process.
Very much, it's a relevant consideration. It's been given to you in evidence as a matter that the submitter has asked you to take account of, and then the way that it's taken account of is a waiting point, which I think Commissioner Bolger was mentioning, and then it's a waiting point overall in terms of your response, and then it's a waiting point in terms of those different levels as well.
So the council's made commitments to do certain things, and that's what we need to have regard to.
And those words should be taken on their face. They shouldn't be, read down at all in my submission. You have to take that document on its face. So can you just give me a minute? I'm just trying to find a spot in Ms McLeod's evidence in relation to the regional policy statement.
It's also referred to in the legal submissions, probably more explicitly.
Thank you. So at my paragraph 17, I just have a couple of comments in response to Transpower's position. It's not accepted by Council. The proposal under consideration will not provide Transpower with a means to properly consider cultural effects in relation to considering alternative sites, routes or methods for new infrastructure under Section 171 of the RMA. It is accepted that the approach in the proposed Ngāi Tahu cultural values provisions under consideration may alter how this is done or how consideration of alternatives is achieved when compared with other territorial areas. However, and I refer there to the acknowledgement by Council for Transpower, utility providers will commonly engage directly with mana whenua anyway. It is submitted that Transpower's acknowledgement that it is able to carry out sufficient due diligence processes through direct engagement with Hokonui Runanga in this manner will mean that it is able to carry out a proper alternatives assessment in terms of 171. And if I can just take that further, and this was a thought I had when you were talking to Ms Bennett about alternatives assessments. She talked about it as a work stream or a process that's followed internally by a requiring authority. So if the consideration of alternatives comes out of Section 171 of the RMA, there's a different process for designations for requiring authorities to follow when they want to put a designation in place. As a part of that, if they're looking at a piece of land which they don't already own, they have to have run this alternatives assessment. The time when an alternatives assessment is tested is if someone doesn't like the designation and it goes to the Environment Court. And then someone can challenge that designation on the basis that a proper alternatives assessment hasn't been undertaken. So then I would expect evidence from the requiring authority to show that they had taken particular steps, what I call due diligence, to assess all of the other options available to them. So in this instance, Ms McLeod talks about taking steps to check whether the location of the lines, proposed new lines, runs through any sites identified in the plan. That's one option. Another option is to give evidence that the requiring authority went to mana whenua, had a conversation based on the information provided in that direct engagement. They then drew some conclusions in terms of alternatives. That evidence can be presented in the same way that evidence of checking of the plan can be presented. So in my submission there is no barrier to this different approach in terms of legislation, but I acknowledge it as a different approach.
This idea that it's a different approach, I just want to test that a little, and it's probably more of a planning question. I will ask Ms McLeod, but my understanding over time, and my experience over time, is that mapping of sites and areas of significance to Māori is a bit hit and miss around the place, and that there's probably other districts, other plans where there are no mapped areas. So, so what is unique about our situation here?
Well, first generation plans also didn't have any such mapping, so people have been taking different steps in different districts as appropriate to what the plan says or doesn't say, and then certainly definitely take your point in terms of any mapping, and some of those limitations are often noted in elsewhere in the plan as explanatory text. But in my submission, different approach perhaps isn't directly accurate, and I guess again this is where I'm talking to planners, and planners are very precise people, so using the correct word but also using a map can be a lot more favourable when you're a planner and you're used to going to this document and finding a source of information. But the document's not failing to provide information, and it's not it's because it is providing key activities which are of particular interest in terms of cultural values, effects on cultural values, but it is also providing a means to get to the end. So it is directive, but it is a directive in an alternative manner in my submission. My paragraph 18, I'm mindful that I've been going for a long time, so I don't, if anyone wants to take a break or we need to take a break, please let me know.
I was going to highlight that we've got Transpower coming online at 1:30 and we're wanting to adjourn at 12:45 so that everyone has a break beforehand, so 15 minutes. But we can come back to you after Transpower, so I'd rather have the quality of the presentation than the speed, thank you.
And if it's at all helpful, I've only got 2 questions left myself.
So my paragraph 18, I just highlight that in the national standards, there is a reference to sites of significance to Māori, but my point is if there are none identified in this district, then that clause doesn't apply here. So I don't agree that this is a issue in terms of applying those national standards. I think it just means that that subclause doesn't apply. In terms of the regional policy point, which I think you mentioned earlier, Commissioner Hovell, I did have a part in my submissions about this, but then I took it out because for me, I can't see in this evidence from Ms. McLeod a direct conflict between the wording of the regional policy statement, or the relevant parts of the regional policy statement and the actual provisions. That direct head-to-head conflict I didn't identify, so I didn't understand necessarily a direct conflict that required me to sit down with the provisions and find a way through. I saw a general direction which engaged with all of the issues that we're talking about today, but I didn't understand the draft provisions that you are considering to directly conflict with these words. So I apologise if I missed something, but I find these words very broadly drafted to give the District Council the ability to consider all of these things without necessarily taking very precise steps. So it may be something I missed.
I think we'll explore it in questions to Transpower and if need be come back to you because it impinges both on the planning evidence and the legal submissions.
Thank you, and that's appreciated. So turning to scope, my paragraph 19, I reference again the Albany North case. While I've used this as a helpful summary of all the cases, I do acknowledge there is other case law that other parties have referred to. In my submission, the Albany North case takes that into account, so I'm not setting the other case law aside so much as trying to assist the panel with one place that it can find all of the key principles. Council for Federated Farmers has suggested that Albany North is not helpful, and I respond to that by saying, while I accept the Albany North case arose in the context of a specific legislative process for the Auckland District, in my submission that process was not special or unique in terms of its treatment of scope issues, and as can be seen from the judgment, it applied all of the previous case law that has been applied to plan processes to date. In my submission, the comprehensive review of scope matters undertaken by a High Court judge in that judgment, with the benefit of full submissions from a range of well-resourced parties, is useful. It is therefore submitted that it does provide a one-stop shop for you, and I would cross-reference the summary in my earlier submissions, which then also refers to the earlier plan process cases which have been relied on in the summary and in Albany North. In my submission, the Albany North case is a High Court judgment, and I cannot see a reason not to take this higher authority or use this higher authority and seek to prefer Environment Court judgments as Council for Federated Farmers seeks to do.
Can I just, because this was where my question came in, don't higher court judgments bind the lower courts and us?
And that's the point I'm making, yeah. And I would just add, Justice Fata wrote that Auckland case, and there's very few High Court judges who are less. He is one of the key. He came from a resource management background. He brings a lot of experience, so it's certainly not one to be set aside lightly. At paragraph 21, I've just sought to take the principles from Albany North and then translate them in a very general manner, so probably at that helicopter view to this process. So in my submission, and this is where the change was to the submissions, Councillor Bolger, so at 21A, I wanted to change the word overlay for basis, please. So in my submission, the notified plan provisions provided a basis which enabled consideration of cultural values for certain activities undertaken in the district. Hokonui Runanga made a submission supporting the notified plan provisions. Other submissions were also made supporting provisions that provided for assessment of cultural values in a manner, this is probably where I should not refer to Apiti Hono, Tātai Hono, in the manner sought by Hokonui Runanga, and I refer there to the Environment Southland submission as an example. There were also a range of submissions received which opposed the notified SASM provisions on the basis that they appeared to result in the classification of the entire district as a SASM. So that we quoted text is taken from the Stony Creek Station submission as an example. So in my submission, the revised provisions put forward for the panel's further consideration at this hearing and in earlier hearings specifically respond to all of those submitters' oppositions and supports, specifically respond to the submitter's opposition to a district-wide SASM approach, so that's that sort of confusion layer. Other concerns from the submitters who may not have fully appreciated how the notified provisions sought to manage the effects of new activities on cultural values, and also responds to the submissions and support. So it is for you as a panel to find a way through all of those submissions, which is not an easy job, I would expect.
And advice you were given to us previously in terms of the test of can submitters or could submitters have reasonably anticipated the outcome of their submission is what we had before us last week, and there's another discussion to be had about what was presented to us this week, and that's, I guess, an issue for tomorrow.
And that's where these principles that have arisen in the context of scope, they all sort of present these different ways of thinking of it, and reasonably foresee what the outcome of their submission, but also reasonably foresee the outcome of another party's submission and another party's submission. And this is the thing, you can sit down and look at one submission and it might not necessarily present a potential outcome, but putting them all together, you can reasonably foresee where it ended up. So another concept which has been used, which is one of these general things, is the workable approach, which is the one I turn to in my next paragraph. So in my submission, a workable approach to the combined positions set out in the submissions has been identified through the plan process, and in my submission there is scope to incorporate these changes as being something between the notified provisions, between the relief sought across each of those different groups of submissions that were made. I accept the transition to a different descriptor for the assessment of Ngāi Tahu cultural values I would submit the transition to a different descriptor has not altered the notified approach to providing for managing effects on cultural values in the plan. Rather, in my submission, it's a prudent response to the SASM label, which has been confusing and unattractive for so many submitters. Council is in agreement with Council for Hukanui Runanga that the actual scope of the provisions now put forward are actually narrowed from what was notified and are a more refined and directive group of provisions to better capture the key activities that may pose a risk to Ngāi Tahu cultural values. And I'm thinking there about that shift from this many activities to this many activities, which has been set out in Ms. Beerin's evidence.
So the challenge for us as a panel is to go back to the original notified version and I guess ignore all the interim ones that have been given to us and look at what is being promoted. In terms of, it could be argued there has been a transition from A to B to C to D, but is the test we should be putting from A to D is what we should be comparing, not the transition that we've had along the way?
My submission would be is that you should not ignore the transparent public process that has also been followed, and I would reference, for example, minute 15 and the other engagement that has happened in a public forum which has enabled submitters to see the path from A to B to C to D. So I think sometimes if you were to ignore the process that was followed and getting from A to D, it might create barriers to seeing the path and understanding the workable approach that has been found. And this is the point with this hearing, is that it has been a challenging one. And it's been a challenging one for everyone, for submitters to understand in terms of what it's responding to and where we're ending up. So acknowledging that point, I would say please don't completely ignore what has been happening through this public process, because it has been public. There has been opportunities for all submitters to be involved. It's clear they have been involved and they have been engaging with the panel on different issues. So I would encourage you not to ignore that public process and when you're getting to D, for example.
Thank you, that's helpful.
I had one that was attached to your paragraph 22, and it was what you were saying before around going, the narrowing down as you've described it. So is this narrowing an important consideration for us in terms of going from something broad to something more specific, and is this around reducing the impact of the change as opposed to expanding? You know, like if it was going the other direction, we might have to think about it differently than the fact that from what was notified, the material impact on different activities and things like that has reduced as opposed to expanded, and why is that so important?
So taking, for example, just the list of activities or key activities which engages with Ngāi Tahu cultural values, if there were 50 and then there were 2, then I would submit that there is a diminishing of the scope of the provisions relevant to that. That's only one way to think of it, and I think that we have talked about that today in terms of you do have to look at it from these different lenses, but certainly when you are looking at it in that particular manner from the notified plan and what that captured in terms of consent processes, I would submit there has been a reduction in what is captured in the proposals that are before you now.
can I just ask, Shelley, the word some activities, do you think that clarifies the activities enough to be acceptable for us?
Where are you referring to? Is it in my submissions?
Yes, in Ms Courtney's submission evidence.
Have you got a paragraph
Which
reference?
paragraph? Yeah.
And I wonder if because we've started talking about key activities as well, that's perhaps another descriptor that we could use, but I am mindful that the evolution of these provisions has been challenging for everyone, so perhaps when we get to some of these finer drafting points, it would be helpful for us as a team to be able to sit down and engage with that again, because we haven't had full opportunity, and we still haven't had full opportunity to really be in the same room and discuss them. But can I come back to you on that and talk to Ms Bennett, and then we can probably provide a response when she's on tomorrow morning.
So are we at the end of your legal submissions?
Final paragraph is just about integration, and there we need to land on a point in terms of what falls into the wrap-up hearing, and what is more in this hearing, and to some extent I would take direction from the panel, and then again this comes back to the point where it is a difficult chapter and we can only present the best we can in terms of moving forward to integration.
It is our intent to come back tomorrow afternoon with some direction, but in the few minutes we've got available, I'd like to ask a general question, and there's going to be some specifics relating to it tomorrow. And looking at it generally, if we are of the view that the scope of what we've been asked to do goes beyond what is reasonably dealt with in the submissions or by way of consequential changes, and if we're of the view that it's appropriate to actually do a variation to the plan, what process should we follow? Because I'm aware of some councils at the time of notifying decisions release variations. In other cases, the variations follow, I guess, after appeals are lodged. So looking at it generally, and there's been a number of topics where the issue has arisen, and it will come up again specifically from submitters tomorrow. So just in terms of process to be followed, if we're of the view that a variation is needed, what is your advice?
So I've put an initial comment on this in paragraph 11 of my submissions, and it's my submission there that the matters of the Part 2 matters and the evidence before you means that it is appropriate for the panel to respond by including provisions in the plan within the scope of what has been notified and submitted on in order to respond to those Part 2 matters and their evidence. And I've submitted there that the evidence that before you would still require you to perhaps then revert back to something more akin to what was originally notified, because you are bound through this decision-making process to, for example, apply Section 6E. If there were other matters that sat outside scope, I would suggest that care should be taken around suggesting those should be dealt with by way of variation, because that is a future decision of council. If it was an appropriate response in your view as a panel to do something further which is outside the bounds of this process, then certainly that information is useful, but it's not something that you can rely on in order to make your decisions on the proposed district plan. You can't rely on it happening, for example, because that decision would have to then subsequently be made. So it's a difficult spot to be in, but I would submit that you need to respond to the evidence by preparing appropriate sections of the district plan to respond to what's before you.
So the implication of that is that we need to check our delegations, but I don't think there's anything in our delegations that enable us to notify a variation to the plan. So it would need to be done as a recommendation back to council, and there can be no certainty that the council would accept that recommendation. So in making our decisions, we need to be mindful of that in terms of seeking to resolve what we have in front of us.
That's right. And if you felt that a variation, or you wanted to make a recommendation for a variation, I would submit that you would need to be very cautious in relying on that recommendation to address, for example, Section 6E matters, because there is no certainty moving forward. So you need to make a decision which addresses the concerns that have been raised within the boundaries that you have been set, which is, I acknowledge, subject to scope issues, so you have to do the best you can within the current scope. If there's a glaring omission, then perhaps that's something that we can deal with procedurally, and the council can, different parts of council can then take steps to seek to respond to. But I would submit you do have a lot of evidence before you to make this decision.
So, yeah, still talking in general terms. So I think you've discussed the process probably as far as we can take it, and there'll be some questions of submitters tomorrow who are talking about it in the context of the Saturn chapter.
Thank you, and I will give it some thought overnight and come back to you, but I'm mindful that in terms of this particular topic, I've addressed you on scope at a sort of a higher level, so if there are specific scope issues as well in terms of particular provisions, please let me know, and I'll look at that more specifically.
Okay, thank you. It is now 12:15. I intend to now adjourn until 1:30. It's now 12:45, sorry, yes. And adjourn till 1:30 when we will be hearing from Transpower. So we are adjourned. Thank you.